welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the latest legal developments across the country. Starting with the headlines. Supreme Court continues hearing Aligarh Muslim University minority status case. Supreme Court directs London Pride to modify trade dress and colour amidst ongoing trademark dispute with Blenders Pride and Imperial Blue. Delhi High Court overturns CIC order on PM Cares Fund information disclosure. Delhi High Court recalls order allowing widow to terminate 29-week pregnancy. Now the headlines in detail. The Supreme Court today continued hearing the case pertaining to the minority status of the Aligarh Muslim University for the fourth day today. The matter is being heard by a constitutional bench of 7 judges, headed by the Chief Justice of India D.Y. Chandrachud, and also comprising Justice Sanjeev Khanna, Justice Suryakant, Justice J.B. Pardiwala, Justice Dipankar Datta, Justice Manoj Mishra, and Justice Satish Chandra Sharma. A significant deliberation revolves around the distinction between establishment and recognition. On this note, Advocate M.R. Shamshad argued today and stated that the establishment of an educational institution involves the exercise of choice. After 1950, it transforms into a fundamental right, and the entire system is obligated to give effect to that right to choice. The act of registering oneself into the Society Act will not be termed as establishing an institution. It will only be considered a compliance of an institution with an existing statute designed to promote excellence. Advocate Shamshad took the bench through the A. Basha judgment, stating it of having a cutting down effect. He contended that the requirement of recognition of that institution existed before 1920. The CJI in this regard questioned if it will be correct to say that AMU owed its existence to the 1920 AMU Act, because before that there is no university. Attorney General R. Venkatramani opened his arguments in the matter and stated that the choice part is given to each citizen, but a higher status is given to minority. Therefore, it enables them to reach a level beyond the other common considerations. The AG further said, Article 30 is premised on the availability of a legal framework, otherwise it will be a vacuum. The CJI on this asked if in the absence of an enabling legal framework, there will be no choice within the meaning of Article 30. In a significant development, the Supreme Court has stepped into a trademark dispute involving a Madhya Pradesh-based whiskey manufacturer selling its products under the London Pride label and the liquor giant Pernod Ricard India Private Limited, renowned for its products Blenders Pride and Imperial Blue whiskies. A bench headed by the Chief Justice of India D.Y. Chandrachud and also comprising Justice J.B. Pardiwala and Justice Manoj Mishra asked the company selling London Pride, why have you adopted the same trade dress and colour and all? The CJI, expressing concerns over the apparent resemblance, also asked whether the said company was open to explore the possibility of changing such trade dress and colour. The court has slated further discussions on the broader trademark dispute for subsequent hearings. A legal action was initiated by Pernod Ricard against London Pride, alleging trademark infringement. The matter reached Supreme Court after a dismissal of Pernod Ricard's appeal by the Madhya Pradesh High Court, challenging the commercial court's decision against issuing a temporary injunction. Pernod Ricard, in its plea against JK Enterprises, the manufacturers of London Pride, have said that the product causes confusion among consumers. The company informed the court that Pride was a pivotal and distinctive element in Blenders Pride and has been in use since 1995. Similarly, Imperial Blue had been part of their portfolio since 1997. The Madhya Pradesh High Court, however, dismissed such claims, perceiving lack of substantial similarity. The Delhi High Court has reversed a directive issued by the Central Information Commission that mandated the disclosure of information concerning the PM Cares Fund in response to a right to information application. The court ruled that the information in question was sought from the Central Public Information Officer of the Income Tax Department and not directly from the PM Cares Fund. It clarified that the Income Tax Department does not recognize the PM Cares Fund as an authoritative entity, emphasizing that the information sought pertained to a third party. The court outlined the provisions of Section 11 of the Right to Information Act, according to which notice must be given to the third party before divulging information related to it. The court held that CIC should have followed this procedure before issuing the order for disclosure of information. Also highlighting Section 138 1B of the Income Tax Act, the court underscored that information concerning an assessee can be provided only with the satisfaction of specific authorities enumerated in the Act. The court further expressed that CIC lacked jurisdiction to direct furnishing of information specified under Section 138 of the Income Tax Act. And even if it did possess the jurisdiction, the failure to notify the PM CARES Fund of the hearing would have led to the invalidation of the order. The decision came in response to a petition filed by the Income Tax Department challenging the CIC order dated April 27, 2022. The court allowed the petition and set aside the said order. The Delhi High Court today recalled its previous order, which allowed a widowed woman to terminate her 29-week pregnancy after the death of her husband in October last year. Justice Subramaniam Prasad made the decision after the centre filed a plea seeking recall of the order dated January 4, 2024, which permitted the termination of pregnancy at 29 weeks, as continuation of pregnancy could affect the mental health, and observed that the right to reproductive choice included the right not to procreate. The centre argued that the court should consider protecting the right to life of the unborn child, as the fetus has a fair chance of survival. The All India Institute of Medical Sciences, where the medical examination of the woman was conducted, advised the continuation of pregnancy for the betterment of the child and the mother. AIMS also urged the court to pass directions after considering the provisions of the Medical Termination of Pregnancy Act, which prescribes an upper limit of 24 weeks for the termination of pregnancy. The medical board stated that it would be feticide in this case, which is neither justified nor ethical, as the fetus is grossly normal. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.